Hey everybody, Zach Wolf here with another great Top 5 Tuesday. This week on Top 5 Tuesday, it's the top 5 ethical issues for lawyers in departing employee litigation. What's departing employee litigation? I'm talking about the kind of lawsuit where an employee leaves one company and goes to work for a competitor. Then there's a lawsuit. The first company sues either the employee or the second employer or both. That can create some ethical dilemmas for lawyers. Let's start with number 5. That's the importance of remembering who your client is. Let's say you represent company A and you often work closely with the president of the company. Suppose that the president calls you up and says she has some questions about her non-compete with the company. Well, in that case, you've got to be careful because you don't want to be giving legal advice to the president in a matter where she could potentially be adverse to the company. Number 2 is to be careful about making yourself a witness in the case as the lawyer. Here's a common scenario. Let's say that the company finds out that one of its employees is planning to leave and join a competitor. So they schedule a meeting with that employee to confront the employee about these facts and possibly to fire the employee on the spot. If you represent that company, they may want you there as their lawyer. And that's probably okay in general, but just be careful because you could become a witness from attending that meeting, and that could limit the role that you can play if there's a subsequent lawsuit. The number 3 ethical issue for lawyers in departing employee litigation is the duty of candor. So, believe it or not, lawyers are generally not allowed to lie. In Texas, we have Rule 4.01, which says that a lawyer shall not make a knowing material misrepresentation of fact to a third party. So you've got to be careful about not making factual misrepresentations. So for example, let's say you are having a conversation with opposing counsel and you represent an employee who has left a company and is accused of taking company documents. If you know that the employee has taken confidential company documents, then you need to be careful because you don't want to deny that the employee has done that and make a material misstatement of fact. The number 2 issue is meritorious claims or defenses. As a lawyer, you've got an ethical duty not to bring a claim in court unless you have a reasonable good faith basis for the claim that is not frivolous. So, for example, if you represent a company who is suing for misappropriation of trade secrets, a lot of times you may not have evidence yet of whether trade secrets were taken and whether they were used. So you've got to make sure you've at least got a reasonable good faith basis for pleading misappropriation of trade secrets. And finally, the number 1 ethical issue in departing employee litigation: conflict of interest. Specifically, I'm talking about the potential conflict of interest between the employee who has left one company and gone to a second company and the second company that hired the employee. In some situations, it may be okay for one lawyer to represent both the company that hired the employee and the employee. But obviously, there's always the potential for a conflict of interest between those two defendants. So you've got to be careful as a lawyer to recognize that potential conflict and to make sure that you act accordingly. Okay, those are my top 5 ethical issues for lawyers that often come up in departing employee litigation. If you liked the video, please hit the like button. Or if you have a comment, leave me a comment. Even better, if you liked the video, please share it with someone you know. And hey, thanks for watching.